I would now like to introduce today's speaker, Jim Cunningham. Jim is an attorney and he's the CEO of Cunningham Legal, an estate planning and trust administration law firm with 8 offices around California. Jim is certified by the State Bar of California as a specialist in estate planning, trust, and probate law. He's also licensed by the State of California as a real estate broker and licensed by the State of California as an insurance agent. So without further ado, I'd like to kick things off by welcoming Jim Cunningham.
Thanks, Jen, and thank you for joining us here today to discuss the single biggest piece of legislation to affect retirement accounts in decades. This is a really big deal. I'm really glad you're here to join us. There's a lot of stuff going on here, and what my job today here is to give you a little bit of guidance on the pros, the cons, and unfortunately the possible disasters connected with the Secure Act. So before we get started, I do have to tell you that I am a lawyer, and the State Bar of California requires me to tell you that I'm speaking and words are coming out of my mouth. This is not legal advice. This is very important. This is not legal advice. This is not tax advice. And this is not financial planning advice. And we're going to talk a lot about that today. But the first thing I'd like to start with is the marshmallow test. Now, this is a test that was conducted at Stanford in the early 1970s. And this is how the test went. There was a room, and there were some toys and some other interesting things for kids, and there was a box. And one of the psychologists put a marshmallow in the box. And so there's a single child here, one child, and this marshmallow that's set in front of the child. And the psychologist tells the child, if you don't eat this marshmallow in 15 minutes, so I'm going to come back in 15 minutes, and this marshmallow is still here, I will give you another marshmallow so that you'll have 2. And what do you think happened? Well, a lot of the kids ate the marshmallow, right? Because they were, going crazy trying not to eat that marshmallow. So when we talk about the Secure Act, when we talk about inheriting IRAs, I want you to think of the marshmallow test, okay? Because a lot of self-discipline has to go into this.
Okay. We are going to launch our first poll question right out of the gate. And the question is, how did you hear about the Secure Act? The response options are the news, advertising, email, my financial advisor, my CPA, friends, or family. Okay, go ahead and take the next 15 seconds to make your selection, and then we'll go ahead and share the results. Okay, it looks like most of you have finished up. We're just going to give you 5 more seconds, and then we'll go ahead and close the poll. All right, so it looks like the news is the top choice for most people.
That is great. So the great thing about the news is there's lots of information, and what I'm going to give you here is a little bit of insight. So the Secure Act is, there's some things here that we're really not going to take too much of a deep dive into, but here's the pros. Here's the good stuff. If you were born July 1, 1949 and later, your required beginning date, the age at which you have to start taking money out of your IRA, has been moved from 70 and a half to 72. Now, this is good news for people who don't need the money out of their IRA. That means you're not going to have that forced distribution for a year or 2 and pay taxes on that, because, one of the things, well, here, what is an IRA? So here's how most people got their IRAs. Is you earned income, you had a job, there was some type of work involved, and you took some money that you otherwise would have put in your pocket, some of your paycheck, and you put that into a 401k or a 403b or a TSA. And that money built up over time, and many of you have rolled that IRA over. So when people separate from their employers, many times they'll meet with the financial advisor or the CPA or the lawyer and start thinking about this, and then move that IRA from the 401k to the, move that money from the 401k to the IRA, and that's called a rollover, right? So when you separate from your employer, you roll your 401k over to your IRA. The old rules where that the April 1st, following the year in which you turn 70 and a half, money has to start coming out. That date has been pushed back to age 72. But if you were born June 30th, 1949 or earlier, guess what? you have to start taking out when you're 70 and a half. It's actually the April 1st following the year in which you turn 70 and a half. There's also a very other important planning device. It eliminates the age restriction for contributions to qualified retirement accounts. So one planning strategy for some of you to consider might be creating a company like an LLC and putting money into a retirement account that is provided by that LLC. So that's kind of granular. That's more for the CPAs and financial advisors out there to talk to their clients about. But eliminating the age restriction for contributions to a qualified retirement account can provide for some very powerful tax planning. Now, here's how the Secure Act, here are the cons. So the pro, we've pushed the age back from 70 and a half to 72. And another, the con is now the money has to come out faster than it used to have to come out. So what I mean by that is, let's take the example of someone whose parents die and they inherit the IRA. It used to be in the 1980s, if you inherited an IRA, you didn't have to take any money out. And then they changed the rules. And those rules were in place for 25 years. And what those rules said is when the person who owns the IRA dies, whoever the person is that inherits the IRA has the option to take all the money out at once, which isn't good because you pay tax, right? Or they can take it out over a longer period of time, and that was tied to their age. So the younger you are inheriting an IRA, the longer you can stretch that IRA out. You take smaller pieces out over a longer period of time. If you're the older you are, the faster that IRA comes out. Well, all of that, with very few exceptions at the bottom of the slide there, spouses, minors, disabled, chronically ill, and someone less than 10 years younger than you, all of those rules are kind of thrown out the window. Now we're stuck with what is called the 10th year rule. Now what that means is when a person dies without one of these exceptions, so what I want to think about, I want you guys to think about is sort of the classic example of parents pass away, they leave that IRA to the kids who are grown. No minimum distribution has to happen for 10 years. And then in the year that contains the 10th anniversary of death, so if a person dies in 2020, the 10th anniversary of death occurs in the year 2030, which is actually 11 tax years. So it's the anniversary, the 10th anniversary, it spreads out over 11 tax years. All of the money has to come out in that 10th year. All of it. It doesn't matter if it's $1 million, $100,000, $1,000, $100 million. And there's some IRAs out there of that size. It doesn't matter. All that money has to come out. And the kicker is you got to pay tax. Now, going forward on the planning, something we need to be very mindful of are income tax brackets. So as you guys know, a person who makes $50,000 pays tax at a lesser rate than someone that makes $500,000. What that means is as you earn more money, the government takes a bigger chunk, okay? So as you know, if you earn $500,000, you're paying income tax at a higher rate than someone who's earning $50,000. Now, I'm going to spend a very brief time on exceptions. Spouses, there still is a spousal rollover. Minors, now I put up to age 26 because minority, a minor is under minority, right, when they are under a certain age, up to age 26. Now, why isn't it 18? Well, it's 18 in California, but California says that you can still have a dependent up to age 26 if they're a full-time student. So this may skew in favor of people who have kids that are full-time students, and those tend to be skew higher socioeconomic, so there's a fairness argument in there. But there is a minor's exception. And then disabled, so this is somebody who's disabled within the meaning of the Social Security Disability Act, and then chronically ill beneficiaries. And that's actually defined under the Internal Revenue Code. That basically means someone who can't work, a chronically ill person. So the Secure Act, a big retirement game changer, okay? I think this creates an enormous opportunity for people to create a tremendous amount of wealth, but there are also a lot of minefields in here. And we're going to go through some examples in a few slides.
Poll question, and the question is, do you currently have an IRA trust? The response options are yes, no, or I don't have a traditional or Roth IRA. Go ahead and take the next 15 seconds to make your selection, and then we'll go ahead and share the results. Okay, we'll just give you a few more seconds. We're almost about tied in our answers, so we'll just give you about 5 more seconds and then close out the poll. Okay, let's go ahead and share the results. And it looks like most of you have said no, you do not have an IRA legacy trust.
So I think the best way to explain this is really to talk about what happens when this fictional person, Bob, inherits an IRA. So this is not Bob, the IRA owner. This isn't Bob's money where he was working in a job and contributed to a 401k and set that money aside and then retired and then drew down on his IRA through retirement. This is Bob, the son of the parents who set up the IRA, okay? So this is Bob when he inherits his IRA. And there are 3 doors, and this reminds me a lot of The Price is Right. So if you can think, was it Bob Barker who was The Price is Right? He says, you know, Bob, come on down. You're the next contestant on The Price is Right. So here comes Bob. He's dressed like a 50-year-old guy, and he's looking at 3 doors. Now, you remember on The Price is Right, you could pick from door number 1, door number 2, or door number 3. And I remember as a kid, somebody opening a door and there was a goat. All right, that's like kind of a vivid memory from childhood. So we're going to open the disaster. This is the goat door, okay? Let's go ahead and open the disaster door. Bob doesn't know what's behind door number 1, 2, or 3. And the one that's X'd out, by the way, Bob cannot do because his parents did not do planning while they were alive. So door number 1, disaster. Folks, 87% of the time, that's a big number, 87% of the time, Bob goes down to maybe the XYZ bank where the IRA is held. And Bob talks to the teller. He stands in line, makes his way to the front, and says, you know, my parents have passed away. And I saw here, I got something in the mail that showed a statement from your bank saying they have an IRA here at your bank. And I have their death certificates. What do I do? Because Bob doesn't know. And I'll tell you something, folks. A lot of lawyers don't have sufficient knowledge in this area. A lot of CPAs don't have sufficient knowledge in this area. And a lot of financial advisors, unfortunately, don't have sufficient knowledge in this area. So when we talked about the marshmallow at the beginning, Bob doesn't know that if he takes this money out, there's a lot of bad stuff that's happening and a serious missed opportunity and a tax disaster. So Bob withdraws the $1 million. He gets a check. Well, what happens is the institution will withhold 10%. That's if Bob is not subject to backup withholding. If he is, they withhold 40%. So what Bob does is he says, okay, you guys hold 10%, that's $100,000, and give me a check for $900,000. And so Bob takes that money and he pays off his mortgage and he pays his bills and he buys a truck and a bass boat and he spends it. The problem here for Bob is he doesn't know what he doesn't know. He doesn't know that the following year he's going to get a 1099-R, which is a form that the bank will send out saying that they've given Bob $1 million of an IRA. Now, the problem is that's taxable. So if Bob earns $100,000 in a year, he now has to pay tax on $1,100,000 in income. And that tax bill is almost $500,000 for Californians. It's about 400 in the high 400s. He's going to get a huge tax bill, has no idea. If Bob doesn't do anything, and I'll tell you, it's pretty unlikely that somebody who inherits $1 million isn't going to do anything. But if he does nothing, he's subject to a penalty for not taking the money out in a timely fashion. I mean, if he absolutely does nothing. So you got to do something. Unfortunately, 87% of the time, people pick door number one, not knowing. They get the goat, they get the, they eat the marshmallow, whatever it is, whatever analogy you want to put in there. Door number two is a missed opportunity. So let's say Bob is one of the 13% of the people that doesn't yank all the money out of the retirement account. Let's say he doesn't do that, and maybe he's got some advanced knowledge of this. Maybe he's listened to this webinar. Maybe he's read our book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer. It's available on Amazon. It's actually a top seller in its class. Here's what Bob needs to do. Bob has to do something, and there's a term, and I don't want to get too technical with you guys, but there's a term called a designated beneficiary. It means a human being with a heartbeat, a human being who is alive with a heartbeat and a date of birth, okay? So sometimes the person who's inheriting the IRA, the name does not appear on the beneficiary designation. So let me walk you back a little bit. When Bob's parents go to the bank and Bob's parents set up their IRA, the bank is going to ask them a lot of questions. And one question the bank is going to ask, who do you want to name as your beneficiary? Now, sometimes people put the name Bob, and sometimes they put Bob's social security number, and sometimes they put Bob's date of birth, but not always. Sometimes people check a box that says, I leave it to my living descendants, my children, right? Sometimes people don't fill out a beneficiary designation, or worse yet, sometimes the institution can't find the beneficiary designation. So when Bob shows up at the bank, sometimes they can't find their own record. Now, it's kind of hard to believe on $1 million IRA that they wouldn't find it, but folks, this does happen. It is not frequent, but it does happen. Now, if Bob's name does not appear in the beneficiary designation, the federal law requires that Bob be identified by the September 30th following the year of the parent's death, meaning his name, his social security number, and his date of birth must be provided to the bank. All right? They have to give that information. What that permits Bob Jr. to do is that permits Bob Jr. to take the money out over a 10-year period or in the 10th year. If Bob does not provide this information by September 30th, Bob has to take the money out over a 5-year period. That's called the 5-year rule. And if you've heard of the 5-year rule, that's a penalty box. I know I'm probably throwing a lot of stuff at you guys, but it's very important to know Bob has to do something after mom and dad die in order to get a missed opportunity. But let me walk you through this. So previous law, we had a stretch out. Bob used to be able to take this out over his lifetime. This was a tremendous wealth generator. So instead of taking it all at once, or instead of taking it all over 10 years, Bob took it out over a 30-year period, maybe 3 or 4% a year until it was distributed. And this was just a fantastic wealth generator. Now, under the Secure Act, you're not going to be able to take that stretch IRA. Now, for your Googlers out there, if you Google stretch IRA, you'll see a lot of information about stretch IRAs. But basically, it was that ability to take those distributions from the IRA over a lifetime. Now the money has to come out in the 10th calendar year, and there are no distributions in the first 9 years, right? There's just no distributions, but it does come out in the 10th year. And so that brings us to the successful outcome. So now Bob's parents didn't do this, and so I think I'm trying to impart to you a story, and we're going to wind the clock back. Now, Bob's parents did consult regularly with their attorney, CPA, and financial advisor. I want you to think of that as a three-legged stool. And for as long as I've been in practice now, 25 years, I've sort of beat this drum, this mantra of you need a team. You need the three-legged stool. A two-legged stool doesn't stand up and a one-legged stool falls over, right? But this is that sort of three-legged stool that you might see somebody milking a cow, like sit down on the stool and milk a cow, for those of you who've milked cows before. So it's very important to have a team together, and here's why. Lawyers are the ones who typically write trusts. Now, Bob's parents can use, and this is not always what happens, and again, this is not legal advice, but Bob's parents can use a purpose-built trust for the IRA. And I want to explain to you what I mean by this. So when Bob's parents are alive, they meet with the lawyer, the financial advisor, the CPA. They come up with the plan. Bob's parents come up with the plan, and the advisors help them come up with this plan so that while mom and dad are living, they own the IRA. But when mom and dad die, they don't name Bob directly as the beneficiary of the IRA. Now, the beneficiary is Bob, right, who gets the IRA. They don't name Bob as the direct beneficiary. They name a trust, and that's very important. This is not your living trust, because living trusts and IRA trusts, IRA legacy trusts, don't play well together. It's, kind of oil and water kind of thing. They don't go well together. These trusts that are used for IRA planning are special purpose-built trusts, so that on the parent's death, when the parents finally pass away, instead of the IRA going to Bob, it goes to this special IRA legacy trust. Now, when Bob's parents die, Bob doesn't take any distributions for 10 years. So remember that marshmallow slide. That marshmallow sits there for 10 years. One thing Bob can do, and this is one really important reason number one to have a trust, Bob could move the situs of the trust. So the IRA is paid to this trust. It's like a bucket. Bob moves that bucket to Nevada. That in and of itself will defer at least $250,000 in taxes. Now, what I mean by that is when mom and dad die, that IRA is $1 million. 10 years go by at 7.2% rate of return. That's called the rule of 72. The money doubles. So mom and dad die, 10 years later, the money doubles. And when that $2 million, if that were to come out to Bob and he's a California resident, that's $260,000 that Bob might have to pay in taxes to the state of California. By having the trust in Nevada, you at least defer that tax under current law. But the good news is there are many cases moving now through the federal appeals courts and the U.S. Supreme Court that are trending. They're moving toward not having to pay that tax to California at all. Okay? So this is possible that mom and dad could set this estate plan up so that down the road, that money may never be taxable in California. And saving $260,000, people, this is real money. And, $260,000, I want you to think of that as a bunch of acorns that will grow mighty oaks. This is, we've had this incredible economic expansion since World War II in California. A great amount of wealth has been created and a great amount of wealth will be transferred. Who knows if that will be the case in the future? It's very important to minimize the taxes, the income taxes that are paid. Another thing about income taxes you need to understand. Income taxes are confiscatory taxes. Now, what is a confiscatory tax? I mean, someone takes it from you. You pay the government that money. You don't get anything back. You get nothing back. I mean, it goes to the general welfare, but you're not getting that money back. Now, that's different than a Social Security tax or a Medicare tax. Those are social taxes, and the definition of a social tax is that you get something back at some point in the future. So when you pay into Social Security, and once you become eligible to receive Social Security, you can take that check. Same with Medicare. You pay into Medicare, you're going to get a Medicare benefit back once you qualify. So by moving the situs of the trust to Nevada, you bypass that state confiscatory tax. The other thing that trusts allow us to do generally, and so the fork in the road here is, do you leave your IRA to a trust or do you leave your IRA to Bob, right? Do the parents leave it to Bob? Do you leave it to an individual or do you have some planning wrapped around the money? Do you have a plan for the IRA? So one advantage with a trust is that it's a separate tax-paying entity. That's how we're able to at least defer and hopefully in the future eliminate state income tax on the IRA distribution. So it's a separate taxpaying entity. Very important planning strategy. There is also the potential of what we call a spray trust. So it may be that if Bob doesn't take any money out for 10 years, when that money finally comes out, the lawyer could build a mechanism, again, working with the CPA and financial advisor, the lawyer could build in a mechanism where that money, instead of $2 million going to Bob, remember that money has grown from $1 million to $2 million in that 10-year period after death. Instead of that money going just to Bob, it is sprayed out to a whole bunch of family members or friends or whomever Bob's parents want that to go to. But again, this is where the lawyer gets involved in talking to Bob's parents and Bob. Hey, and this is something, folks, you got to do periodically, right? You have to pay attention to this. You have to review this far more frequently than your overall estate plan. So a spray trust, it goes to more people. Why would you want to give that money to more people? Because the more people you have, they're generally going to pay that money at a lower tax bracket or a lower tax rate. Again, someone who makes $500,000 pays taxes at a higher rate than someone who makes $50,000. So if you can spread that $2 million and spray that out among family members, that may be a good thing, and that's something to consider. The other big planning strategy is a charitable trust. Now, what is a charitable trust? So the idea here is that money is paid to Bob for a period of time that may be 20 years, conceivably less, but typically 20 years or Bob's lifetime. So there's kind of a fork in the road. You got to choose one of two strategies or a combination of strategies. And what that says is Bob gets a percentage of what's in that trust for his lifetime or 20 years. And then whatever's left goes to charity. The advantage is that you can get around that 10-year rule, meaning that all the money's paid out in 10 years and you can stretch that out to 20 years or for Bob's actual life. Now, the last strategy on the slide here is the Roth conversion. And what we've got in our next slide, but not yet, is I really want you to pay attention to this. This is the single most powerful financial planning tool that you have to deal with your IRAs for two reasons. Number one, whenever you take money out of your IRA that's not a Roth, you've got to pay income tax. Secondly, while you're living, if this is your money that went into the 401k and now it's an IRA, as you convert that money to a Roth IRA, if your IRA is a Roth IRA, you do not have a minimum distribution. Let me repeat that again. If you have a Roth IRA, you have no minimum distribution. That's a very powerful tool. You know, I met with a third-party administrator from the San Francisco Bay Area. One of his clients is one of the founders of PayPal. And when he sold his interest in PayPal, he put together his money. Some of it was in an IRA, and he cobbled money together and did a Roth conversion. And so what he did is he got taxed on that money, and he had $500,000 in his Roth IRA. He was one of the earliest investors in Facebook. He bought $500,000 of Facebook when Facebook had a valuation of $5 million. This investor now has over $3 billion in his Roth IRA. Just get your head around that, $3 billion in a Roth IRA. He has no minimum distribution. If he had a minimum distribution, if he had put that in a normal IRA, his minimum distribution would have been $100 million a year from his IRA once he turned 70 or 72 now.
We actually have a question from Margot. She's asking, can you expand more on the special purpose-built trust?
Yeah, the special purpose-built trust is a type of trust that is not a living trust. So there, you know, in the financial and estate planning and tax world, we have living trusts. We have revocable trusts. We also have irrevocable trusts. So a revocable trust is one that you can change. And that's typically I have a living trust, and lots of people have a living trust. And that's where you say, hey, if I die, everything goes to my wife. And then when my wife and I pass away, it goes to our kids. What we're talking about here, and that's the primary vehicle for handling your assets. When I say special purpose trust, I mean that this trust, when we use an IRA legacy trust, there are some very technical terms that have to be included in there in order to effectuate a 10-year stretch. If you don't have those rules in place, you're boxed into a 5-year period of time. So in order to get that 10-year deferral of withdrawals from your IRA, if it goes to a trust, it has to be a special purpose-built trust, not your regular living trust. So let's compare the doors. So I know for a lot of people, when they see a bunch of numbers on a spreadsheet, they kind of gloss over. I'm going to walk you through this, so don't glaze over here. Door number 1 was the disaster. And that's the one where Bob walked through, and that's the one where Bob went to the bank. He didn't know what he didn't know. He didn't know any of the rules that you now are familiar with. And so what he did is he withdrew the IRA. He will keep $528,000. He will pay $472,000 in tax. Now, I don't know if any of you have paid $472,000 in tax, but we had a client who sold his company for over $10 million, did not choose to do tax planning, and he said, you know, I'm okay paying the tax. Well, the problem is he sold his company in the spring. He didn't have to pay his tax until the following April. And when he wrote that big check, and it was for many millions of dollars, he cried. A grown man cried because he had to pay millions of dollars in taxes. So this is not just imaginary stuff here. This is real. $472,000 in taxes. That's a lot of money. Ending up with $528,000. So that's the marshmallow, right? Now, door number 2 is a missed opportunity. Now, why is this a missed opportunity? Because if you look at door number 2, let's say Bob got good advice, but the parents did no advanced planning. So Bob met with his attorney, a CPA, and a financial advisor, and the 3 of them working together advised Bob and said, Bob, you can do a 10-year stretch, meaning a 10th year stretch, meaning you can take all the money out in that last year, or you can take a little bit of money out every year. And what you can see here is the real beneficiary of waiting is the government. Because if you take your money out over 10 years, that's the 3rd line down, the government gets about $500,000 in taxes. And Bob gets a little over $1 million, which, you know, I mean, look at that. He's getting 2 marshmallows, right? So 500,000 is what he would have gotten if he took all the money out. If he waits 10 years, he gets twice as much money. And these are after-tax numbers. So doesn't it make sense to wait 10 years? And that's why I have the marshmallow slide there, right? It really makes sense to wait those 10 years so that you double your money. Now, that makes sense. Now, if you take that money out a little bit at a time, you pay the government $500,000. If you don't take any out and you wait, the government gets almost twice as much in tax, but guess what? You get about the same amount of money because this is tax bracket management, right? The more money you earn, the higher rate you pay of taxes. So mindfulness, so this is why after Bob inherits, he needs to meet with the 3 people now, why would he need to meet with a lawyer every year? The reason he might need to meet with a lawyer is what happens if Bob dies? Let's say Bob's 5 years into this. Who inherits Bob's inherited IRA? Well, it depends. There are actually 4 possible outcomes. Number 1, Bob's estate. Not a good, right? Literally his probate estate, meaning you would have to probate that. That's not good. Secondly, it goes to the original contingent beneficiary, meaning when mom and dad set up their IRA, and they named Bob as the beneficiary, sometimes there's a contingent beneficiary. Well, that might be Bob's kids. It could be somebody, who knows? The third one is Bob's kids, right? And the fourth one is Bob gets to choose. Okay, that's actually the most common is that Bob gets to choose. But if he doesn't choose, then we go back to whatever the documents are, whatever the default documents are with the institution. So if you wait 10 years, you kind of get the same amount of money. The government gets more taxes.
We have a question from Robin, and she's asking, can you put money into a Roth if it's not earned income?
Let me put it this way. Monies that go into retirement accounts have to be earned income. You could do a Roth conversion, right, from an IRA to a Roth. In that sense, not all that money's earned income, but it's the earnings on the earned income that went to the IRA. So I would say, if your specific question is, can you put unearned income into a Roth? The answer is no, but you can effectuate a Roth conversion with IRA money that's grown from 100,000 to 1 million, for example, right? So it's not just the earnings that you put in that you can convert, it's the whole balance of the IRA. Very important question. Thank you for that.
Okay, it's time for our last poll question. And the question is, when was the last time your attorney, CPA, and financial advisor last met? The response options are within the last year, within the last 5 years, or never. Please go ahead and take the next 15 seconds to make your selection. Okay, we're going to give you about 5 more seconds, and then we're going to go ahead and close out the poll. Okay, it looks like most of you have responded with never.
Well, those days are over, and let me tell you why. A Roth conversion must be done while you're alive. Mom and dad have to do this while they're alive before Bob inherits the IRA. Now, if you look at these numbers, net 10 means after taxes 10 years later. Obviously, the Roth at $2 million is the best number. That's 4 marshmallows, right? If the 528 is 1 marshmallow, the Roth after 10 years is 4 marshmallows. And then it's 8 10 years later. That Roth is the most powerful investment tool available to Americans today, without a doubt, the most powerful tool. Folks, if you're 70, and I'll make the math easy, if you're 70 years old, and you have $1 million IRA, and you're going to live to be 90, that's 20 years, you should consider, I'm not suggesting that you run out and do it, but you should consider talking to your CPA, financial advisor, and lawyer every year to figure out whether and how much you should convert from your traditional IRA to your Roth. Here's the problem. When you convert from a Roth, when you convert from an IRA to a Roth, you typically, that's a taxable event, right? If you take $50,000 out of your IRA, you have to add $50,000 to your income. But this is why you need to meet with your accountant and attorney and financial advisor. There are a lot of things that you can invest in that give you an income tax break. There are a lot of ways that you can structure your investments in a way where you pay less income taxes. So when you hear, this is a theme in politics today, billionaires aren't paying their fair share. Now, you can agree or disagree with that, but the reality is, if you have wealth, you can pay less tax. It's just the way it is, right? So there are strategies, and if you're a lawyer or a CPA or financial advisor out there, you're probably familiar with many of these strategies. But I will tell you, the Roth conversion is one of those spaces that, it's not exactly, not all aspects are 100% within the sphere of competency of lawyers, CPAs, and financial advisors acting alone. Financial advisors are typically focused on, planning, financial planning. Are you going to outlive your money? I mean, hopefully the answer is no. CPAs are focused on the taxes, and they're focused on essentially, what happened last year and what can we do this year to mitigate taxes going forward. Lawyers tend to take a broader multi-generational approach, and we need to look at what are your kids' tax brackets, right? If you're going to leave your IRA to your kids, your grandkids, what's their level of wealth? What are their tax brackets? How can we maximize the legacy that hopefully you'll leave your loved ones and give less to the government? So I would just say, on the hierarchy of planning, The Roth is something I would highly recommend that you guys consider. And here's another thing you need to know about advisors. There are some advisors and some CPAs, I have their cell phone number. They have my cell phone number. And we together do a great job for our clients. If your attorney, financial advisor, and CPA don't all have their cell phone numbers, they're not working close enough together. So if I have to call a CPA and go through the assistant and blah, 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 stuff's just not going to get done. So these advisors really need to work closely. And it's not that it takes a whole lot of time, but we really need to work closely and have access to each other. So your marching orders would be, number one, make sure all your advisors have their respective cell phone numbers. Very, very important. I do want to finish with the charitable. So if you can go back to the prior slide. So there's another strategy, which is involving a charity. And the idea here is that it's kind of a way of side-skirting this 10th year rule or the 10-year payout. Instead of your IRA going to Bob, so instead of Bob getting the IRA, it goes to what's called a charitable trust. Now, there are two variants. Those are acronyms. I'm not a fan of acronyms, but those are the two big different types of trusts. And they have different outcomes. So if you look 10 years later, when you look at the total that Bob gets, you can see it's less. It's kind of, it's lower than the 10th year stretch or the 10-year withdrawal. But as time goes by, those numbers start approximating a Roth. And so what I think we're going to end up seeing with certain clients is kind of a patchwork, a hodgepodge, a cobbling together of different strategies in a way that makes sense. So it may be that for some beneficiaries and for some IRA accounts, you do a 10-year withdrawal. For other beneficiaries, other IRA accounts, you do a Roth. And then you may consider a charitable, so that charitable remainder unit trust or charitable remainder annuity trust for different situations. So again, this is why working with the three advisors and who have competency in this area, but working with the three advisors, the attorney, the CPA, the financial advisor, it's very, very important to have these three working together. So that the marching orders I would give you today would be, number one, make sure you have an attorney, a financial advisor, and a CPA, right? And if you do your own taxes, you know, unless you really, really know what you're doing, it's best if you have a CPA involved in the mix, because there are a lot of technical things, technical approaches to this. And if you handle your own finances, again, it's good to meet with a financial planner who can do some modeling and some forecasting. This is less about investments, and this is the type of investments, and it's more about making sure that you don't outlive your money and making sure that it's moved around intelligently. So marching orders, make sure you have a CPA, financial advisor, and an attorney. Make sure they have their respective cell phone numbers, and also look at a Roth. I think that's the first order of business. Start looking at that. I'm not telling you to go out and do it, but I think it's a good idea to look at it.
That was really great information, Jim. Before we move on to the Q&A, and we do have quite a few questions coming in, I wanted to mention that Cunningham Legal is offering each of you a free phone consultation with one of our attorneys. Please reach out to us at team@cunninghamlegal.com or give us a call at 855-250-9988 to schedule. Okay, with that, we're now going to answer some of the questions submitted during today's presentation. And as a reminder, you can continue to submit questions through the questions pane in your attendee control panel or through the chat icon. Okay, Jim, the first one we don't have a name for. This person is saying, we set up a Roth and are partially converting our rollover yearly to a Roth to take care of the education for our 4-year-old grandson, and had counted on this being stretched over his lifetime, and the Secure Act messed up the plan. Now what can we do so he doesn't have to take the payout over 10 years?
Well, the minor exception is for your own minor children. It does not include minor grandchildren. So you're correct. The Secure Act does giveth and it does taketh away. I think you're on absolutely the right track based upon what you've told me, looking at the Roth conversion, meeting with your advisors. and figuring out the math on that. And it's really tax bracket arbitrage. The other thing is the Tax Act of 2017 lowered tax brackets until January 1 of 2026. So now is the time, 2020, now is the time to start looking at Roth conversion, because those brackets are going up. And depending on who our next president is, this is totally apolitical, but these laws change all the time. We could end up with a 77% marginal tax bracket. So it's very important to consider a Roth conversion get it while the getting's good.
Great. Okay, so our next question is from David. He's asking, can anyone put money into a Roth IRA, or are there income limits?
Yeah, so this is a financial advisor question. There are income limits for contributing to a Roth, but there are no income limits on converting an existing IRA. So if you said, I want to set up my own standalone Roth IRA, there are income limits. Some employers, I know our employer, Cunningham Legal, and we do have open positions for trust administration paralegals, so get the word out. But we do have a Roth 401k option. And that means that you, instead of doing a normal 401k, check with your employer and see if they permit a Roth 401k. If they don't permit a Roth 401k, ask them to change it so that they do.
Okay, great. Okay, so we have a question from John. John is asking, what is the situation if you don't use a financial advisor and your CPA does only your tax returns?
Yeah, it really, I think it depends on the amounts you're talking about. If you're talking about, converting a chunk, 50,000, 20, 30, 40, 50,000 a year, I think you probably need the advisors. Smaller amounts, I'm not sure if paying the fees is worth it, frankly, if it's a smaller amount, just to be honest with you guys. But I would recommend that you consult with a qualified. The reason that I say a financial advisor, this is not a stock picker. This is somebody who sits down and goes over with you. This is more of a budgeting thing, like going forward, this is your income, this is what your savings rate is, this is some imputed rate of return, your risk tolerance, and they kind of get your sort of, I heard this thing recently called ETM, estimated time to a million. So they are going to forecast and get a game plan together, but work closely with your CPA, financial advisor, and lawyer.
Thank you. Okay, so the next, Shauna is pretty much pointing out that in the slide where we did the comparison, she said that there was zero tax for the Roth, but your folks had to pay the tax. I'm assuming she had said that the kids are paying the tax. So she is saying, is there a benefit to the parents for converting beyond prepaying the tax for the person who inherited?
Yeah, you know what, Shauna, great question. This is why you need a lawyer, CPA, and financial advisor looking at this every year. So going forward, it's really changed the game. We need to be looking at what are the benefits. And again, this goes back to tax bracket arbitrage. So if you're in a 22% tax bracket, it might make sense to do a Roth conversion until you hit the next bracket level, or it might not. It makes sense to have a conversation with the CPA about how much you can convert before you hit the next bracket, and then talk to your financial advisor. Well, what investments, how can I move my assets around so that I get some tax benefits from the nature of what I'm investing in? Now, for example, you can invest in solar credits. I mean, this is not about investments or anything, but that's one investment where when you put money in, you get a tax benefit that may offset some of your Roth conversion.
The next question is from Mike, and he is saying, I just did my estate plan in 2019. Do I need to redo my plan all over again?
I think this is less about redoing your plan and more about financial planning going forward, financial and tax and estate planning going forward. You might need a redo, you might not. I just don't know. But on that note, we're happy. I would recommend that you give us a call and set up a phone consult, and we'll be happy to go over that with you. And that's what I recommend each of, frankly, anyone who's listening, like, why wouldn't you just pick up the phone and get a free consult with a lawyer? We know what we're doing. We can let you know if, like, hey, I really think you should be meeting with your financial planner, estate planning attorney, and and CPA or not. I mean, it might not be, this might not be for you, but you won't know unless you reach out, and we're here to help. So.
Okay, we have time for probably one or two more questions. Robin is asking, if you only have $500,000 in assets, does all of this apply? Do you need more money to think about all of this?
Well, that's a great question. I think if you had a $500,000 IRA and you're 50 years old, I'd be thinking about it. If you're 95 with the $500,000 IRA, I mean, I haven't met any 95-year-olds with any IRAs because they weren't working then. But so I think it depends. But I would say 500 is getting close to the cutoff. And I would just say, we mentioned disabled beneficiary. If you are leaving money to a loved one with special needs, a disabled person, the planning is totally different. And I think it's worth it. We've done advanced planning for amounts as little as $50,000 because the money is that important to the person. I mean, literally, this is like life-changing money. So I think it really depends on the context. Some people would say 500,000 isn't that much, but to some people, it could be a real life-changing amount of money.
Okay, our last question is from Amberts. The question is, I am a retired government employee. Can I contribute to a Roth?
Well, thank you for working for the government and keeping us safe and the roads paved and all that good stuff and the drinking water safe. You cannot contribute money to a Roth unless it is earned income. So you can go get, a job doing something and earn some income. That's one alternative. Secondly, you could convert your existing IRA, 403B, TSA 457, whatever you might have being a government employee. You can convert that to an IRA. The other thing you could do is create a company like an LLC and capitalize the company, put money into it, pay yourself a salary, and set up a 401k inside of the company. So there is a way, and this is where I said there was an earlier slide that said there's no more age limitation. There is a way that you can stuff money into a Roth if you set up your own company and your own pension plan inside the company, and you can put away up to a couple of $100,000 a year and take that as a deduction. So what we're doing for some clients is they're capitalizing a company, they're paying themselves $200,000, and then they're paying themselves $200,000 into the retirement account inside the company and getting a deduction, and then they're doing a Roth conversion for $200,000, and it functions as an offset. So good stuff.
Thank you so much, Jim. It looks like our time is just about up. So if we didn't get a chance to answer your question, we'll be sure to reach out to you after the webinar and answer you directly. And don't forget to contact us to set up your free phone consultation, and you'll see that information on the screen. Within the next 24 hours, you'll be receiving an email with a link to today's webinar, and you'll also be able to view past recordings on our YouTube page, so you'll definitely want to check that out. There's a lot of great content on there. And so on behalf of Cunningham Legal, we thank you so much for joining us today. Have a good remainder of your day. Thank you.